I've seen brokers that have done absolutely everything right and still have to defend these cases right up till trial. Some of these companies, and they come out and say it, hey, we're creating a standard. Oh, whoa. You're going to create a standard for my industry. Companies need to be really careful that they don't get sold on something that they think is a quick and easy fix, because there's no such thing. The broker used a third party's scores and said, oh, under the SMS, this carrier is safe. And so we had to get that third party company's CEO on the stand, and he had to admit, well, no, we can't exactly recreate the FMCSA scores.
So welcome to Freightbeat. It's a podcast by the Transportation Intermediaries Association. I'm Patrick.
I'm Merritt.
And we're here each week to discuss the biggest issues and topics in freight, logistics, and how this country moves. We're really excited to kick off this new show with you to give the brokerage world a voice and to make sure that every piece of the supply chain has its chance to talk about what matters.
For our first guest, we have Annette Sandberg, former administrator of the FMCSA. She's overseeing the safety rules that govern trucking and commercial motor vehicles across the country. Annette has sat at the center of some of the most important conversations in highway safety, and it's great to kick off Freightbeat with Annette because she understands both sides of the equation, the intent behind federal safety policy and the day-to-day realities of running a transportation business. As brokers grapple with decisions like the recent Supreme Court ruling around the Montgomery case, and increased scrutiny on negligent hiring, there can be very few people who can connect the dots as clearly and as honestly as she can. Annette, we really appreciate you joining us.
Thank you. I'm glad to be here.
So Annette, Merritt just gave the kind of 30-second recap of your life, essentially. But in your own words, how did you go from being in law enforcement into being the second administrator of the FMCSA? I didn't realize it was actually younger than I had thought. And then into the consulting and the further legal work that you do today.
Certainly. Well, when I started out in law enforcement, I actually started as a truck inspector. So that was my first job in the Washington State Patrol before I became a trooper. So I had some background in trucking. Obviously rose up through the ranks in the Washington State Patrol. My last position there was chief, so I ran that agency for 6 years. And during that time, I had an opportunity to meet some of the leaders in the transportation arena in the United States. And I actually met a woman named Mary Peters, who went on to be Secretary of Department of Transportation after Norm Mineta. And she convinced me to go back to Washington, D.C. and work in the Bush administration. So my first role back there was in NHTSA, the National Highway Traffic Safety Administration. And then the secretary, Mineta, then asked me if he could advance my name to the president to lead the Federal Motor Carrier Safety Administration. So it was kind of a series of opportunities and chances, and it worked out perfectly.
Wow. Okay. So when you stepped into the FMCSA administrator role, what were your kind of key priorities at that time? And how did you balance that political pressure you maybe have had kind of with public safety advocates and as well as industry pushback? How did you kind of maintain those many balls in the air?
Yeah, it was kind of a unique time. One, I came in just after 9/11. So that was an interesting time in the federal government in and of itself. But then, two, the FMCSA was only 1 year old. So it had just been peeled out of federal highways and was created as its standalone agency by Congress. So as basically a baby agency, there was a huge regulatory backlog, regulations that Congress had told Department of Transportation to roll out as it relates to motor carriers. And so that was one of the things that the secretary asked me to try to tackle right, from the very get-go. There were about 32 rulemakings that were outstanding. And probably the largest, which everybody still remembers to this day, was hours of service. And hours of service pretty much encompassed my entire tenure there at FMCSA. So really, we were trying to deal with the regulatory background, stand up a brand new enforcement agency, and make sure that we were trying to fulfill our responsibility, which was really about improving highway safety as it related to commercial motor vehicles.
Interesting. And so what carried over from your time running the Washington State Patrol into how you approached trucking safety and regulation at FMCSA? And I imagine some of those early experiences you had kind of shape how you operate today, but just curious what that translation was like for you.
Yeah, I think the big thing, and this is kind of how I played it when I was in the Washington State Patrol, and I carried this over to FMCSA, and it's really about enforcement. And not that we enforce with a heavy hand. I used to tell troopers, you have a lot of discretion in who you write a ticket to and who you don't. The same with FMCSA enforcement people; they have a lot of discretion in who they really hammer, lay the book on them and give them a lot of violations, or who they try to work with to become compliant. But enforcement's key because the regulations don't mean anything if you don't bother to enforce them. And as a brand new agency, FMCSA hadn't really been in an enforcement mode when they were in federal highways, and so we tried to get them to shift that focus a bit more to enforcing and really trying to work with those carriers that wanted to improve and maybe didn't have all the knowledge and skills that they needed to be compliant. But then those carriers that clearly had no interest in being compliant and were trying to, backdoor the rules, is to hit them with the book. And so it's kind of trying to do that balance of enforcing the rules that are there, but then still working with businesses to advance their compliance.
Wow. Okay. So obviously you've been inside the agency making the rules, enforcing the rules, as you noted, and now you're outside helping carriers and brokers kind of live with those rules and what they mean. Uh, why do you think that dual perspective of the legal framework and the real world experience is especially important for brokers right now, given the environment we're in?
I think it's important because I think some people forget the complexity of the rulemaking process. They think, hey, just fix this rule and it'll be better. But I can tell you, like hours of service, I mentioned that at the beginning. That hours of service rule encompassed 4 years while I was with FMCSA. And it just kept cropping up and cropping up. The first go that we had at the rule, we had hundreds of thousands of comments. And we have to, the agency has to review all those comments and take them into consideration when they're drafting a final rule. That's why rulemaking doesn't happen in a year or even 2 years or 3 years. It takes forever. And part of that is good in some ways because you don't want the agency just flipping out rules that maybe nobody can live with. But at the same time, the process is a little bit slow. And so I think it's important for brokers to understand that the agency has to have that balance. And that if they want to be part of the rulemaking process, the best thing they can do is bring good data to the table. Just saying that you don't like a rule isn't enough. But if you have data to say, hey, this rule is going to impact my business negatively this way, and provide that data, that's data that the agency has to take into consideration. And so I think that that's really important.
How do you convey that data directly to the FMCSA and feel like, you're making sure that that data is actually being digested and used for the rulemaking?
So, obviously, when a rule starts and it's in the rulemaking process, there's a way to provide your comments online. There's actually a rulemaking website that all the agencies use. And I have worked with a lot of clients to help them craft their rulemaking comments so that one, they make sure that they come to the attention of the agency in a timely manner, but two, that they craft their data in such a way as it directly points to specifics in that rulemaking. So if somebody's not sure how to do it, contact either an attorney or somebody that's done it before, and have them help you craft those decisions. But I know, for example, TIA often comments on rulemakings, and they have people in their staff that understand what the rulemaking process is, what data would be required, and how to format that data. So I strongly encourage companies to reach out to their associations and others to say, hey, how do we craft comments? And how do we present our data in a way that makes it compelling to assist in this rulemaking?
Is that rulemaking process? I mean, is that structured, right? Like you submit the comment, or could one ask their representative, right, in Congress to kind of help? I don't want to say, wait on, put their finger on the scale, but you know what I mean? Like do advocacy effectively in a more traditional sense of interacting with your elected representatives.
Certainly, there's two ways to try to influence the outcome of how things are going to look. But once a rulemaking's opened, the agency has to publish everything. So even if a House member contacts them, they have to publish that meeting in the rulemaking docket. So really, if you want to try to influence the change, you probably want to do it before the rulemaking or maybe after the rulemaking. And mostly that would more likely be in the form of legislation that changes maybe the structure of a rule or what a rule actually means, or maybe it clarifies some aspects of that rule.
Oh, fascinating. Okay, thank you.
Yeah, no, that's really interesting. So, how do you describe FMCSA's core safety mission, and where do you think that brokers and carriers kind of misread that? I mean, I think that there's a lot of people feel like there's kind of a shroud of uncertainty there, or they don't fully understand. But I think, good administrators such as yourself help kind of uh, make things a little bit shorten that gap, I would say. But can you talk a little bit more about the core safety mission and how it's often misread?
Yeah, I mean, the core mission is actually very, very simple, and it's in the authorizing act that created FMCSA. And that's basically that the agency's there to reduce crashes, injuries, and fatalities that involve large trucks and buses. That's the long and the short of it. That's supposed to be their overarching goal, and everything they do needs to focus on that. Now, obviously, they have a very big mission beyond that core mission. So they have a big regulatory mission on regulating brokers, regulating carriers, hazmat, all of those things, all the other rules that play into that. But the long and the short of it, and the one thing that I was tasked with the entire time I was there, was answering to Congress on, are we reducing crashes, injuries, and fatalities as it relates to commercial motor vehicles? And you can even go to the agency's website. You can go to their authorizing statute. That's the statute that created the agency. And it said the reason we're creating this agency is for this reason and this reason only. And I think people sometimes they get their own personal little issues and they say, I need this taken care of. I want the agency to focus on this. The agency has hundreds of things that they need to focus on. But the administrator knows, because they get asked by Congress all the time, what are you doing to reduce crashes, injuries, and fatalities? And so everything that they prioritize to work on has to go towards that core mission.
So obviously for our TA members and really just 3PLs in general, obviously the people we hope are watching this debut episode, what do you see as their real responsibilities in that realm on safety and carrier selection versus some of the myths that circulate within the market and within the industry?
Yeah, so I think first and foremost, FMCSA is the agency responsible for safety. I think everybody, it doesn't matter who you are, plays a role in highway safety. I play one every time I get out there on the highway, and it's how I behave around other vehicles, around other users, whether it's pedestrians or trucks, whatever it might be. And in that respect, anytime we interact, I think we all have a certain responsibility. But to say some segments have more responsibility than others, I think would be improper. And to me, TIA's role and brokers' role and 3PL's role is really to select good, reliable motor carriers. And in the process of doing that, they hope they're safe. Now, what I say is hope is because nobody can predict safety. You look at the data that's out there. I mean, if there was some system that could predict, I get this carrier, I can predict that they're going to have a crash. Those people would be making hundreds of thousands, millions of dollars. But nobody can do that. Not even FMCSA can do that. They can't predict. And so I think we have to be careful about how we define safety because everybody has a different definition of safety. And I can tell you, particularly the plaintiff's bar has a much different definition of safety that would push it way beyond anybody's realm of understanding. And so to go back to the question, really, I think what TIA and their members need to focus on is doing a good job of vetting and selecting compliant and reliable carriers.
So it's really it's a team. When I say a team effort, I suppose everyone in the supply chain from shipper to broker to carrier, we're all involved basically, right?
That's correct.
Okay.
Great. And speaking of liability or responsibility, I think it's a good time to pivot to the case that's on everyone's mind, of course, which is Montgomery versus Caribe 2. For a broker listening on their commute, and I know this is a tall task, but as best you can, could you try to explain in plain language what happened during that lawsuit, and what are some of the facts, and how did we end up at the Supreme Court in the first place?
Certainly. And I know probably some people will take issue with the way I describe this because I'm going to make it really probably too short, if anything. But I'll try to boil it down to the essential elements. So a company retained C.H. Robinson, a freight broker, to arrange an interstate transportation load of plastic pots. C.H. Robinson contacted with Caribe, that's the trucking company. They were a federally licensed motor carrier to transport those pots. And after picking up the pots, that Caribe's driver was traveling through Illinois, veered off onto the shoulder, and hit another tractor trailer that was stopped on the side of the road. That tractor trailer that was struck was being driven by Mr. Montgomery, thus Montgomery versus Caribe. So Montgomery brought suit against Caribe, Caribe's driver, and C.H. Robinson as the freight broker, alleging that Robinson negligently hired the trucking company. So basically, the case ended up in the Supreme Court because the district court, where it was originally filed, held that the F4A, which is the Federal Aviation Authorization Act, I'm just going to keep calling it F4A after explaining that, preempts state laws related to price, routes, and services of the trucking industry, expressly preempted Montgomery's negligent hiring claim against C.H. Robinson. The district court further held that the claim did not fall within the F4A's safety exception, which provides that the F4A's preemption provision shall not restrict the safety regulatory authority of a state with respect to motor vehicles. The Seventh Circuit of a Court of Appeals, that basically is in Illinois, affirmed the lower court's decision. So basically what that means in layman's terms is that C.H. Robinson won on summary judgment, both in the lower court and the appellate court. But then both Mr. Montgomery and C.H. Robinson asked the Supreme Court to review the case. And I know a lot of people would be confused, well, why would C.H. Robinson ask that since they won? And partly they asked is because there were other circuits around the country that had ruled differently. And because of that split in the circuits, C.H. Robinson and other brokers really wanted an answer to this F4A preemption issue. And that's how the case ended up in the Supreme Court.
Were you surprised to see that it ended up being a 9-0 unanimous decision in the Supreme Court?
I think a lot of people were. I mean, it clearly shows that all the justices felt the same way about the underlying issue.
Mhm.
So what does that signal then? Like what should brokers be kind of interpolating from the fact that it wasn't just, a 6-3 or 5-4, but in fact it was unanimous? What should we be reading this as far as going forward? Like obviously that means more lawsuits will be coming, but is there anything you think they could interpolate from that?
I think a 9-0 decision to me simply shows that the court was unified in their opinion that the F4A, under the F4A, individual states retain their authority to regulate safety with respect to motor vehicles under the Act. And the definition with respect to motor vehicles should be construed more broadly than what I think certain individuals believed. So basically, what it means is, in some respects, not a lot has changed, other than you no longer have this preemption in some jurisdictions. Keep in mind, other circuits had already ruled that F4A did not apply. And so brokers always had liability in those jurisdictions. What this has done is removed this kind of what I would call early exit in a case because the preemption no longer is available to a broker.
Yeah, we've been hearing a lot. A lot of people. I feel like they're kind of split one of two ways. They either see this as like a doomsday, oh no, what are we going to do kind of thing, or they're like, hey, this already existed. You should have been working in this, in this way all along. But practically speaking, how does Montgomery, what does it change in terms of how easily brokers can be sued? And how far negligent selection claims might actually proceed in court. What changes in a more practical sense?
To me, it's changed nothing about how easily brokers can be sued. Lawsuits are so easy to file, and brokers always have been subject to these kinds of claims. The only thing that's changed is in some jurisdictions, brokers can't get out of the case sooner. They actually have to go through more expensive discovery to show that they had appropriate vetting mechanisms in place. All the F4A did, and that exemption that was there before, was allow brokers to ask for summary judgment to remove them from the case sooner. What's happened now is they have to stay in the case longer. They're subject to more discovery, and they're going to have to show early on in the case that they took appropriate action to vet the carrier that they selected and that they selected the carrier reasonably.
So obviously something that doesn't get talked about a lot here, or has been mentioned, and obviously maybe matters to our members who are brokers. But what about the shipper side, right? It seems like the focus has been on the broker for a lot of this, but this will also have an effect on them, which seems to have been glossed over a little bit in all the hullabaloo, I suppose.
Yeah, so I always used to, I've done a lot of work with shippers. So I do work with motor carriers, shippers, brokers. When shippers are trying to decide, hey, do I use a broker to broker my freight? I always used to say, listen, if you use a broker, that broker stands between you and the lawsuit. Because if the carrier's involved in a crash, the next in line to get sued is going to be the broker. And then you're kind of far removed from that transaction, particularly if you didn't give that broker specific, hey, you must do this, 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 and this. So for those shippers, and a lot of shippers do this, a lot of shippers will broker their own freight, not broker, but they actually tender their own freight to motor carriers. They have a list of motor carriers that they historically use, and they'll say, hey, we'll give you these loads. In that situation, the shipper is going to be on the hook if they pick the carrier incorrectly. And to be honest with you, the shippers I work with, I tell them, you have to have the same kind of process as a broker does in how you select a motor carrier. What are you looking at? How are you making sure that that carrier is legitimate, that they have appropriate authority, that they have insurance? What is it that you're looking at to make sure that that is in fact a reliable carrier? And if they're doing nothing, they're just going out and trying to find the cheapest motor carrier, I think they're going to be in very big trouble. So for shippers, it's a bit of a wake up call, which is if you're tendering your own freight directly to motor carriers and you're not doing some kind of vetting of those motor carriers, you will likely be involved in these suits in the future for negligent selection and negligent hiring of a motor carrier.
So I guess obviously we've heard a lot from the carrier and broker side about the Montgomery case, but just in your opinion, I suppose, was this a good ruling for the shipper community? Was it a bad ruling? Was it a business as usual? This doesn't impact us one way or the other. I mean, I'm just kind of curious around how it impacts them in particular within the broader chain.
So I think some shippers were paying attention because obviously the U.S. Chamber of Commerce weighed in the Supreme Court. So they clearly had members that were concerned as it relates to this. I think it's for a lot of shippers, it's probably business as usual. However, I will tell shippers this if they're listening, is whether you're selecting a motor carrier or even if you're selecting a broker, you need to do appropriate due diligence. You need to know what you're expecting them to do, and you need to know how they're going about selecting. If you're selecting a broker, how they're selecting motor carriers, and if you're selecting a motor carrier, how you're ensuring that that carrier has been properly vetted.
So speaking further about kind of the ways, the information people need to weigh when choosing the proper carrier and making sure everything is above board, what specific safety data, FMCSA ratings, inspection history, basic scores, what do you expect your clients, when you're speaking to them to review? And you're talking about I've heard a lot about keeping a really well-maintained paper trail or documentation of how the decision was made, what the decision was like when it was made. How are you talking to your clients post Montgomery? I'm sure you already had these conversations before, but they're even more highlighted now. So what's that look like?
Certainly. So I'm not going to give you a specific laundry list because I think every broker out there has to kind of look at what their risk profile is. How many carriers do you have in your network? How have you already vetted those carriers? What kind of ongoing monitoring do you have for those carriers? What kinds of things are you looking at? And I can tell you everybody's a little bit different. And so it's hard for me to say, hey, you need to look at X, Y, and Z. I will tell you that there's some things that you absolutely have to have. You have to have a policy. You have to be able to articulate why you selected elements of that policy. So, hey, we're going to look at, obviously, you want to look at, do they have authority? Do they have insurance? Have we done fraud checks? Have we looked at carrier reliability? So, have they had service failures? Those kinds of things. There are some things that you just really should be watching for. Has this carrier been caught double brokering? Because to me, once you allow a carrier to broker your load, you've lost all control over vetting because you don't know who that third party downstream is and how reliable they are. So obviously having the policy, training to the policy, documenting that you're following the policy, and then not making exceptions. So most of the brokers that I've worked with that have had issues are where they had employees that made exceptions. Oh, it's a Friday afternoon. We really have to get this load out. Oh, I'll go ahead and just take this carrier. They're not quite up to our standards, but we think they can haul the load. And sure enough, that's the one that gets involved in the crash. So those are the real critical things. The thing, though, that I would warn people about, and this to me is a very big concern because I hear a lot of this post Montgomery, is, oh, we should use SMS scores. So the FMCSA, CSA, SMS scores, those basic scores that, I think there's some third party commercial companies that are out there saying, hey, you should use these scores and here's what you should do. It's easy for those third party commercial companies to say, hey, we're recreating these scores and you should use them because this is how FMCSA rates a carrier. Well, one, step back. That's not how FMCSA rates a carrier. Two, those scores were taken down from public view in 2015 and they still are not back up. And they were taken down for a really specific reason. And that's because they weren't reliable. The next thing is Congress told FMCSA to have the National Academy of Sciences do a study on the CSA SMS system. And even in that study, the National Academy of Sciences said this is not predictive of future crash risk. So if it's not, why are companies using it? And I think they use it because it's fast, it's easy, it's simple, and they've had a lot of people try to sell it to them. I caution anybody, if you're going to be using data, you better know what the data actually says. You better know how to use it appropriately, and better be well educated. Don't just buy somebody's marketing material that says, oh, this is an easy way for you to vet your carriers. Because I can tell you that the plaintiff's bar, every time you think you kind of, oh, I meet the standard and the plaintiffs are going to leave me alone, it's never enough. They keep moving the bar. They keep changing what you have to do, and it's never enough. And so I think companies need to be very, very cautious of what they're buying and how they're doing it. And if they can even articulate why they're using it, rather than just buy somebody's kind of off the shelf marketing of, hey, this is going to be your new carrier vetting.
That really seems like something I've been hearing a lot from a lot of people, right? Is honestly, it's a fast-paced industry, but patience and making sure you're checking all the boxes, even in the brokerage world, is probably the most important thing you can do to avoid any major hiccup. And honestly, something probably might happen anyway because, like you said, nothing is predictable. The world is a very unpredictable place. I just wanted to speak about those. Obviously, those TA members we do have are mainly small, mid-sized shops. Like, what should they prioritize so they can manage all these new risks without grinding operations to a halt? Is it just that patience? Is it just being careful? I mean, like I said, it's hard to stand out and succeed when you're small and fighting up an uphill battle most days. What in your they be prioritizing?
Particularly for the small guys, I think if you wanted to prioritize one thing, I would recommend that they work with their insurance carrier. Because obviously the smaller people are going to be more reliant on insurance. to defend against these claims, and they want to make sure that they're in lockstep with their insurance carrier, that, hey, we're doing the vetting properly. Because sometimes it may be the carrier that says, hey, we think you need to tweak your policy. But obviously that's the first step. And then obviously go back and review your policy in light of Montgomery and say, what are we doing it? Why are we doing it? How are we doing it? And does it make sense in this post Montgomery world? Now, keep in mind, I'm going to remind you again, most brokers already were doing all these things because only some jurisdictions gave you the shield of F4A, not all jurisdictions. So almost all brokers, because they, transport freight, or they, send freight through all 50 states, already had exposure to those jurisdictions that did not give you F4A preemption. So, it's just look at it in that context and understand, hey, our litigation costs may be more because we're going to have to defend more cases. But if we were already defending them successfully in these other jurisdictions, like the Ninth Circuit or the Sixth Circuit, we should be able to still defend them in the Seventh Circuit. It's just we're going to have to take the case further. And so it's really talk to your insurance carrier, look at your policy, make sure your employees understand what that policy is and train to it on a regular basis, and make sure that you're documenting.
So one thing that you brought up, and I think this is often a lot of times who these folks kind of go after, the small, mid-sized people who are looking for that silver bullet. They just want to have the scores. They want to purchase them from somebody and just be like, okay, we're good to go now. We've got all the safe drivers. We never have anything to worry about anymore. I mean, that's usually kind of, unfortunately, the lowest hanging fruit. But aside from that, what are some mistakes that you're seeing in response to this? How people are either overreacting or underreacting? I mean, you brought up a lot about I think a lot of it is remain calm, review your procedures, check your documentation, talk to your insurance carrier. But what are some other things that you see people doing that you either caution against or you would recommend doing more of?
Yeah, I think the overreaction I see is companies leaning towards, oh, I want to use the SMS scores, without remembering why they're not publicly available. And oh, by the way, I would caution them, question those people that say that they're creating those scores for you. They're not getting those scores from FMCSA. They are trying to recreate them using their own algorithm. And I have a case that I testified in as an expert for a broker, where the broker used a third party's scores and said, oh, under the SMS, this carrier's safe. And then when we got into discovery and we actually got the FMCSA scores, found out that they were over threshold in some of the FMCSA basics. And if that had been the case, the broker probably wouldn't have used them. And so we had to get that third party company CEO on the stand, in a deposition. And he had to admit, well, no, we can't exactly recreate the FMCSA scores. So this gets back to my point of, don't just believe the marketing material. Oh, hey, we'll give you the FMCSA scores. No, you're recreating them and they're not exact. Know what you're getting. The other thing is, don't forget, there's a reason why those scores were taken down and why they're still not publicly available. And if they're not publicly available because Congress told the agency to take them down, and in fact, FMCSA has a warning on their website that those scores are not indicative of a carrier's safety stance, why would you use them and think that they're going to shield you from some lawsuit? Because they're not what you're saying they are. And so I think people need to look back in history and remember they got taken down for a reason and they're still down for a reason. Don't use bad data to make your decisions.
Kind of the age-old adage, if it sounds too good to be true, it's probably too good to be true.
That's correct.
That is crazy too, though. They're just kind of, it's a score they don't want to use because it wasn't predictive, and then they're just doing it wrong. They're doubling down on something wrong. That is a bad way to play poker and the worst way to run a brokerage, it sounds like.
That's correct.
I mean, do you have any suggestions on how members can pivot and just adjust these changes in the near term? Obviously, we've talked about just being careful. We've talked about training your staff, but I'm not asking you for a silver bullet, perhaps, but maybe a couple of good guiding words that you might have for a broker out there.
I hate to sound like a broken record, but again, review your policy and don't just review your policy once. I think brokers should review their policy every year because things change. Maybe there's going to be some new data set that comes out there that they need to consider, but you need to review that policy every year. You need to make sure that your employees understand what it says and how it works, and then that you're documenting. So it kind of sounds like a broken record, but I think that those the cases where I've testified on behalf of brokers and they did those things, I can tell you it made the case much easier if the broker representative could articulate how they made decisions on vetting. They knew what was in the vetting policy. They could show that it was followed and that all employees were trained. It makes a much stronger case in defending these claims.
And it seems like with experience, I mean, this is kind of a weird way to look at it, but as more cases kind of come to light and people get kind of, I don't know, used to these changes and how people, cases are being decided, they will, by virtue of that, learn how to document better, adjust their processes so that when it comes their time, I mean, so it's not to say it would be like clockwork, but it's like they're ready to go for whatever comes, as opposed to the world they were living in before. Where it was like, well, fingers crossed, it's in one of these states that doesn't have the preemption rule, and we just don't get in trouble. But now it's like there's a lot that remains to be seen. So how would you recommend folks stay on top of like what is going on and how things are unfolding so that they can, it's kind of a Herculean task for some to make these big changes to their paperwork or their documentation or how they do things. But how do you recommend people kind of like start small and make big changes that compound over time to be big?
Yeah, so by starting small, again, you don't have to make wholesale changes to your policy if it's been working, but just have that initial conversation with your insurance company. Here's what we're doing. Here's how we're doing it. Here's how we would go about saying we're doing the best vetting possible. Now poke holes in it and help us improve it. To me, that's a small thing. You just want to take that incremental step. As far as staying ahead or abreast of all the changes that are going on out there, and I'm not pitching for TIA, but I can tell you industry associations are a good way. Yeah, they're a good way because they're keeping track of all the things that are going on out there, whether it's with motor carriers or shippers or Congress, and they keep their members abreast of kind of all these ongoing changes. And I've always said, I even tell trucking companies that I work with, how come you're not involved with your state trucking association? Most of those, memberships are not very expensive, but it's extremely important for you staying abreast of regulations and things that are happening in your respective state. Same with brokers. They should be involved with TIA, and TIA will help them stay abreast of all those changes.
Obviously, you talked about companies being seduced by these third party quote unquote SMS scores and things like that, and how you should not do that. But are there any tools? I don't expect you to pitch a specific company, but a type of tool brokers could start leaning on technology wise that could help them stay compliant, help them stay safe, and help them stay on the right side of things.
Yeah, without naming a single tool, I can tell you any tool that helps you document your process and do ongoing monitoring. So I know that there's some platforms out there where brokers can put their contracts up. They can send those contracts electronically to the motor carrier. The motor carrier signs it. It gets stored on that platform in perpetuity. Or if there's changes later, they can electronically send that. The same with document the vetting process that they go through and how they did that, and that gets documented and kept on that platform. And then any ongoing monitoring that they're looking at. Hey, does the carrier still have, appropriate insurance, authority, those kinds of things. So those kinds of tools I think are important because they help you store that documentation in one place. And that's important when you get into discovery because believe me, the plaintiffs are going to ask for all of that. And it's easier if you can timely respond to that discovery and have it organized because, I've worked with a lot of clients, even in motor carriers in audits. those carriers that are stumbling around trying to find a driver file or a maintenance file or whatever, believe me, it makes the enforcement person nervous that they don't know what they're doing. Same within discovery. If you have everything lined up and you're organized and you can show that you're doing the same thing every time for every carrier, that really shows to the jury or whoever the decision maker is that you have a good process and it's solid.
Excellent. I want to kind of go back to your time at FMCSA. So you talked about making the most of being a part of association and, being an active member, being involved in your industry. When you were at the administrator at the FMCSA, what did the associations that worked best with you, how were they most successful in kind of keeping aligned with you and, keeping up that relationship so that when the time came, that relationship was there? I think a lot of people kind of, kind of just hope things are going to work out, or maybe they will meet the administrator when the time comes, or the FMCSA is on, I think there's, a lot of feeling that's on Capitol Hill. I live in Kentucky or something like that. But how can members of an association talk to the FMCSA, or how do they kind of do that most successfully in your tenure?
So in my tenure, not only did I attend association meetings, so obviously TIA has an annual meeting and maybe it's in Washington, D.C., and they would invite me to come to that meeting. But I know they have working group meetings as well. And they would invite either me or members of my administration to attend those meetings, particularly as it related to various aspects of the agency. I think early and often communication is absolutely critical. You kind of alienate the administrator if the only time they hear from you is when a member of Congress comes in to blast you about something that the association said you did wrong. And especially when you didn't hear it from them first. Now, I know that the current administrator, Derek Bars, he and I have had a number of opportunities to talk. He comes from a similar background that I did, which was from law enforcement, and he's been very open to discuss and have ongoing meetings about respective issues. He's been very available, in my opinion, much more so than some in the past. So I think it's important that you engage early and often. And if there's an issue that you're really concerned about and you're going to go to Congress about, I think you owe the administrator at least the first opportunity to hear it. And you may not agree, and he may know that you're going to be going to Congress, but at least you gave him first shot at it.
How often did a congressperson come in your office and blow you up because someone complained? Oh, yeah. Oh, even worse. Oh, oh dear. I'm sorry that happened. So let's look into our crystal ball real quick and just kind of look out 5, 10 years, right? How do you see broker responsibilities kind of evolving in the safety ecosystem as courts and regulators respond to cases like Montgomery that are sure to happen?
Yeah. So I think for all the players in this space, as there's more data out there, I think we're all going to have to evolve our systems. Data, there's a lot of data, and of course, a lot of it gets misinterpreted, but it's important that we understand what data is there and what data is available and how potentially it could be used. So I think for brokers in particular, the things that I've seen that have impressed me about brokers that I never saw on the FMCSA side was I think more brokers know which carriers are chameleon carriers or trying to evade the regulations based on name changes. All of a sudden, you have a dispatcher that's dispatching 20 trucking companies instead of one. And there's just these little red flags that pop up. And to be honest with you, I think in a lot of respects, brokers have more touches on motor carriers than even FMCSA does because they're dealing with them every time they tender a load. And so I think that in the future, really 5, 10 years down the road, or even within the next couple of years, if there's a way for TIA and brokers to work with FMCSA to feed them that information of, hey, here's red flags that we're seeing on these particular carriers. Because quite frankly, the brokers that I've worked with don't want to work with those carriers they're concerned that they're evading the regulations or they're going to, rip off a load or something like that. It's important that that kind of information can be shared back and forth. And I know in past administrations, I've actually worked with a broker to try to get to FMCSA some of this information, and they didn't want to see it. But I don't get that sense from Administrator Bars. I get the sense that he's very open and wants to deal with these bad actors. And so I hope that there's a way that we can begin looking at some of these issues and the information that TIA has in their respective niche. And it's really about fraud and carriers that are constantly changing names and ownership and those kinds of things, that they can help FMCSA see some of that information and help the agency put those carriers out of business.
So it's really about that those pipelines of communication, right? Like you said, the brokers having the everyday touch point of all of a sudden this carrier is slightly different, obviously, or it could be fraud, could be something going on. It really is about
Correct.
those pipelines of communication. Wow, okay.
Yeah, because to me, it's a big signal if a carrier has double brokered.
Mhm.
That's a bad sign. And it's a bad sign that they're trying to like either pass off loads that they can't handle. They're not being honest in some way, shape, or form. If they've changed names a couple of times, there's a reason why. And usually it's to evade regulatory authority or tax or something. But that's not somebody anybody wants to do business with. And so I know that TIA has like TIA Watchdog, and that's a good thing because their members can put carriers that should be on that watch list in there. And I know that almost every broker I know uses TIA Watchdog as one of their vetting tools. And I think that that's important. But any of those kind of tools that become available, I think, are critical to sharing that information with the regulators if they're willing to look at it to help get some of these companies out of business.
It's interesting. Like, it seems like there is a reluctance. I mean, it makes sense in a way when cargo theft happens, where a company, we constantly hear this is how much was reported, but this is the tip of the iceberg. There was a ton more that actually happened. And it makes sense as a company. You don't want people to think, hey, we get stolen from. But at the same time, if you don't share that information, then you can't be helped. So if you're in that kind of situation and you want to kind of try to maintain an air of anonymity, but also help the industry, because I think the FMCSA can only do so much. How can brokers kind of try to work together um, to make sure that each other is aware? Because I think it's like if we all work together, we all, there's success for everybody, as opposed to, well, I won't tell them because they'll experience the same thing, and that's just competition. It's like if
Yeah.
we all figure this out together, then we're all going to be in a better situation here.
Yeah, that's where I think TIA Watchdog plays a very legitimate role. So, TIA set that platform up where members can warn other members, hey, here's a carrier that's a problem. Any tools like that that the association can put together, I think are very helpful because I I, I don't know of any broker. I'm sure that there's some out there because there's always shady businesses, but I can't imagine somebody saying, "Oh, I want somebody else to get this carrier, have this carrier stick it to them."
Yeah.
I mean, nobody wants it, and they certainly don't want. Oh, I hope that broker X, Y, and Z gets this carrier because they're probably going to get in a crash and kill somebody. I mean, anybody that's doing business that way has no business, being in this industry, because as I said at the very beginning, I think we all play a role in trying to make sure that we're doing business with good, safe, reliable, compliant carriers, and that we all have our little role to play wherever it may be in trying to make sure that we're all contributing.
So kind of to wrap it all up, right? If every TI member listening or watching took one kind of concrete step this quarter, based on what we've been talking about today, what do you hope? What do you think it should be? Where should they be taking that first step?
I think the first step is looking at your contracts with carriers, looking at your policy, and then again caution about who's selling you data and what they're trying to sell it for. Uh, I have a colleague, Brandon Wiseman, that just published an article recently in Freightwaves talking about kind of the misnomer of using the SMS and why it's dangerous. It's kind of all those points that I raised earlier about why it's been taken down, why it's unreliable, why it's not predictive. Companies need to be really careful that they don't get sold on something that they think is a quick and easy fix, because there's no such thing. And they need to be cautious about the steps that they take and that those steps are reasonable and defensible.
Great. This might be a redundant question. I just have one more. But, obviously these people that are selling things like that are clever. They don't just come out and say, I mean, maybe some do. We can fix your problem. Like we're going to make everything go easy for you. But like, is there any kind of story that you've heard or any kind of buzzwords that are out there that get hooking people who otherwise might know better? I mean, they're successful because they're good at selling things. So is there anything else you would say, hey, be cautious when you hear these buzzwords?
Yeah, I think some of these companies, and they come out and say it, hey, we're creating a standard.
Hmm.
Whoa, whoa. You're going to create a standard for my industry. That's why when I work with brokers, I tell them, I'm not going to tell you what to do because you're the broker. I'm just an attorney, and I'll advise you. But I think they're trying to create a de facto standard to sell their product. And then, and some of these companies are actually serving as expert witnesses for plaintiffs, trying to then push their de facto standard. And that to me is very, very concerning, because really, clearly, all they're trying to do is sell their product and make more money. They're not trying to make the industry better, in my opinion. They're not trying to help brokers. They're just simply trying to sell a product and make more money. And so I would really caution brokers to jump on a quick bandwagon thinking, oh, this is going to be quick and easy, when in reality, I've seen brokers that have done absolutely everything right and still have to defend these cases right up till trial.
Hmm.
And they're very difficult. But, the plaintiffs always move the bar. I've had cases where the motor carrier did absolutely nothing wrong, but the plaintiff's vehicle crashed into the truck. And what the plaintiff argued in those cases, and there have been several of them, is that if the trucking company hadn't been there, the crash would have never happened.
Okay.
And they still are trying to blame the trucking company and the broker for being there at that particular point in time. So, cases take all kinds of forms and they're all very fact based and very specific. The best thing a broker can do is, again, have a policy, review the policy, document, train, make sure you follow it every time and don't make exceptions.
Amazing. Well, that's a great note to end on. Annette, this has been super helpful. For all those listening along, I know when it comes to your current work, in addition to consulting through your own group, TransSafe, you're also of counsel with Childress Law. And Childress Law is a veteran-owned small business which provides legal counsel to transportation-related public and private companies, particularly in the areas of DOT regulatory compliance and the implementation of complex safety and transportation programs. You can view their website at childresslawpllc.com. We'll put the link up here as well. But is there anything else you'd like to tell our listeners about getting in touch or your work with Childress Law?
So I've worked with my partners at Childress Law for a number of years. We all primarily started in the motor carrier space, and then obviously have worked with brokers and shippers as it relates to motor carriers. We're not out trying to sell a specific product or anything. We're just trying to really help everybody make the system better. And so the advice and consulting that we provide is really to help review policies, make suggestions on how it might be shored up, make it defensible, and also make sure that whoever's using the policy can articulate what it is that they're doing. One thing that we find is a lot of people throw out terms related to motor carriers, but they don't know what they really mean. And I can tell you, you don't want to be in that position when you're being deposed in a case. If you're going to throw out a term like SMS, you better know what it means. If you're going to throw out a term like a safety rating, you should know what it means, those kinds of things. But that's what we specialize in. We can help brokers and their employees understand these terms and what's going to work best for them. and shore that process up.
Fantastic. Well, again, Annette, thank you for being our first guest here on Freightbeat. Listeners out there, appreciate you listening to our first episode. This has been Freightbeat. Don't forget to rate, review, and subscribe to our podcast on all your various podcatching apps. I've been Merritt.
I've been Patrick.
And we will see you guys next time.